Welcome back to the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is Attorney Alexander Napolin. I'm joined by Attorney George Abato every Sunday at 3 p.m. discussing a new topic in workers' compensation law and employee rights. If you work in California, we strongly suggest that you subscribe to our channel and hit the notification bell so that you don't miss out on these important discussions that will help you if you're ever injured at work. Remember that this is general information that's meant to help you, but it's not legal advice. If you need legal advice after a work-related injury, dial our injury helpline at 844-984-8414. So if you're injured in California, you have a workers' compensation claim, and you might hire a lawyer to help you,
Right.
and the lawyer will file a claim at the Workers' Compensation Appeals Board. That's a standard protocol. And there's also circumstances where certain skilled workers in California who are part of certain unions have carve-outs. They're not police officer unions because those aren't carved out, although they have special presumptions. We discussed that in our last episode.
Right.
But there are union workers, like, for example, longshoremen,
Right.
who are carved out of the normal workers' compensation dispute resolution process, and they go to special alternative dispute resolution.
Correct.
What's this mediation process look like if you're in one of these union carve-out cases?
Right. So first off, when you go to speak to an attorney and you already know you're in a union, you've been working this job for a while, you know that you have a union rep, please let the attorney know. That's vital information for a lot of things, but definitely for this alternative dispute resolution process. ADR, it's called mediation arbitration. It falls under the ADR process. If you let your attorney know that you're in a union, then they will already know to reach out to the ombudsman, to reach out to the defense attorney that's assigned the case, and go through that. And the process is very, very different. If you've ever been involved in a workers' compensation claim, you know that it's filed through the board, and then if anything happens where you need to speak to the other side, they're not responding, you need medical treatment, it's not being provided, then you file for a hearing, you file a DOR. Sometimes the alternative dispute resolution process is a lot quicker. It's a lot more clean and lean. So I wouldn't say it's a bad thing, Alex. Have you encountered many problems through the ADR process?
Usually it's a little, like you said, it's a little leaner, a little meaner, a little quicker for the injured worker.
Less red tape.
Definitely. I mean, there's more, I feel like the ones that I have done, that it's been a little bit less contentious with the employee.
Correct.
Rather than at the Workers' Compensation Board.
Right.
In a denied claims context. So yes, if you are a union worker, you need to let your workers' compensation lawyer know, or you need to find a workers' compensation lawyer who understands how this situation works and how it differs. Not be filing a claim at the Workers' Compensation Appeals Board accidentally, only later to have to dismiss it and waste a bunch of time. So if you're a union worker and you think you might be part of this alternative dispute resolution process, definitely give our injury helpline a call, 844-984-8414, because we're lawyers who understand how to go about helping you in this more lean process, getting you through.
Right. And I do want to point out, Alex, that with a regular workers' compensation claim, we already discussed how you have a right to a neutral doctor, and usually insurance companies don't want to go through an agreed medical examiner. I personally think that a lot of times it's in the best interest of all parties to go through an agreed medical examiner, but the insurance companies, I think their train of thought is, if we go to a QME, which is a neutral doctor provided by the state, then they might not give any permanent disability. It could be zero. If we get a QME, that's very conservative. If we go to an AME, an agreed medical examiner, more likely than not, there will be some type of permanent disability. That could be right, could be wrong. But either way, an agreed medical examiner is a lot faster because both sides are pretty much in agreement to be okay with whatever that doctor says. Now, the reason I brought that up is because when you go through the mediation process, it's a lot easier to get an agreed medical examiner. When you do your first mediation, you're going to be in front of as Alex said, a retired workers' compensation judge. And at that time, you can even say, Your Honor, we'd like to go through to an agreed medical examiner. The defense attorney's there as well. They could not like it. They might object. But sometimes the judge says, Yeah, I think you guys should. And it's going to be very hard to tell the judge no. Usually in the regular process, it's just us requesting an agreed medical examiner. It's very easy for the defense attorney to tell us, nope, my client doesn't like that. We're not going to do it. But when you have a judge there and he's overseeing the whole process, he's going to ask, why not? Why would you not go to an agreed medical examiner that you both know is a good doctor and get this going as quickly as possible? So that's one very, very important aspect of a mediation process that could actually help you out a lot. And if you don't have an attorney, as Alex discussed, on your side who's done this before, they might not even request an agreed medical examiner. They just might go through the QME process without even thinking about doing that. So once again, I just wanted to point that out. There are several different things that you can accomplish much quicker, with a lot less red tape, and it could be very advantageous to the injured worker as opposed to going through the whole workers' compensation appeals process through the board with filing DORs, with filing expedited hearings, with filing for hearings, having to go in front of a judge, having to go to court. This is way quicker. You can talk to the ombudsman. You can talk to the defense attorney. You can reach out to the judge. With the defense attorney and try to get things done as quickly as possible. It's not as lengthy. It's not as convoluted as going to the appeals board. But Alex, what does a mediation look like? Who's there? What happens? What is the process like once you reach a date for mediation?
If you are watching this video and you're saying, what are these guys talking about? They're saying this mediation is something that I need a lawyer for. Well, there's going to be a judge at the mediation. Usually it's in a conference room. I think the ones that I've done are like at a hotel usually. That's where the carve-out cases go.
Right.
And the ombudsman is sometimes there, and the defense attorney's there. Maybe there's an employer representative there, and then your lawyer. And if you don't have a lawyer, you have the ombudsman, but really you're on your own. And that's what you can expect. You can expect maybe sitting there for several hours, hashing out your different issues, presenting to the judge your perspective. Maybe there's a back and forth.
I see the ombudsman as kind of like a public defender. Sure, they're there and they're on your side. They want you to get a fair outcome. But at the same time, just as with a public defender, when you go to court on a criminal matter and you don't have money to pay for an attorney, they have too many cases that they have to deal with. And a lot of times it's not because of them. It's not because they don't want to help, but maybe they might be overworked and they don't know your case as well as they should. And they don't have the proper information to pull out different things from your case and make them go your way, make your case more advantageous for you. So an ombudsman is there for your benefit, but at the same time, I don't think it replaces an attorney on your side at all whatsoever.
It doesn't.
Alex, once the arbitration process is done, do you have to live with that decision that the retired workers' compensation judge has given?
You do have a right to an appeal, I believe.
You do if it's non-binding arbitration. So it's very important that your attorney looks at the carve-out agreement. Some carve-out agreements have binding arbitration included.
Okay.
Some are non-binding arbitration. So it depends on whether you're in binding arbitration, which you should know, or non-binding arbitration. If you're in non-binding arbitration, you can file an appeal after that decision is made. You have 25 days to file an appeal, so you should do that immediately. You don't want the clock to run out. If you're in binding arbitration, so sorry, so sad.
Yes, that's correct.
It is what it is.
Yeah. And it's in the union contract.
Correct.
It's another thing that you're going to want your lawyer to review.
Right.
So bring that to your lawyer's attention, as George was saying near the beginning of the episode. Tell your lawyer, hey, I'm in a union, because the lawyer is going to have a completely different analysis on what to do and how to tackle your case if you're in a union versus not a union. So go to a lawyer as soon as possible. Make sure you give them the facts of your circumstances, the truth, what's going on.
Right.
So that concludes, I think, our discussion on alternative dispute resolution, union cases, carve-out cases. If you're in one, you need to call a lawyer as soon as possible. Dial 844-984-8414.
We'll see you next week. Once again, if you have any questions, comments, concerns about carve-out agreements, if you're in a union and you want to know more about the workers' compensation process, or if you did have a union claim and you have questions about that and you're maybe feeling some more injuries and you're still in a union, give us a call. You can reach us through, once again, our Facebook and through the number 844-984-8414, and we can help you out with that.